Therefore, on count one, I sentence you to 25 years to life in state prison.
The courtroom is quiet when Mr. Scott's name is called, but the silence is deceptive. It is not emptiness, it is anticipation. The judge, the attorneys, the deputies, everyone in that room knows the history. They know the patterns. They know the failed promises. Each person is aware that this is not just a hearing. It is a confrontation with repetition, with risk, and with trust that has already been tested and broken. Mr. Scott stands in front of the judge, not for the first time and not for the last. Weeks before, the court had given him freedom under specific conditions. Those conditions were not suggestions. They were clear, deliberate, and necessary. One instruction stood out among all the rest. He was not to return to a certain location. That place was deemed dangerous, not because of vague assumptions, but because it had been the center of prior problems, prior confrontations, and prior violations. The court had drawn a line in the sand, and Mr. Scott had crossed it. The defense. Attorney rises, acknowledging the facts before them. There is no effort to obscure the truth. There is no claim of misunderstanding, no attempt to deflect responsibility. Mr. Scott had chosen to ignore the restrictions placed upon him. His attorney admits that he has put himself in a bad position. There is no strong excuse. The acknowledgement itself sets the tone for the hearing, because when excuses vanish, only choice remains. The defense then begins to explain the consequences of continued incarceration. Mr. Scott has applied for Social Security benefits. His disability payments, which are already uncertain, could be disrupted further by confinement. There is also a health concern, a medical injection costing $10,000 that cannot be administered while he is in custody. The consequences of delay are not theoretical. They are real, tangible, and urgent. In addition to this, he has a new job opportunity waiting, one that requires his presence in the community. If denied release, not only will his health and financial stability be compromised, but his chance at productive employment will also vanish. These are not fabrications or exaggerations. They are real-life consequences of pretrial detention, the kinds of arguments judges hear on a daily basis. Jail interrupts healthcare. It stops income. It strains family relationships. The court understands all of this. Judges are trained to weigh these considerations carefully. But understanding the hardship is not the same as granting a release. The law demands more than empathy. It demands prudence. The prosecution then outlines the real issue. This violation was not minor. Mr. Scott did not merely step into a forbidden location and leave quietly. Once there, events escalated. Police were called. Officers were allegedly assaulted. The same outcome that bond conditions were designed to prevent had unfolded. The risk materialized exactly as predicted, demonstrating why such restrictions exist in the first place. At this point, the courtroom attention shifts. The discussion is no longer about inconvenience or hardship or sympathy. It is about control. It is about patterns. It is about the consequences of repeated choices. The judge does not need to ask whether this seems familiar. The history of previous hearings has already made the answer clear. Every face in the room knows what is likely to follow if history repeats itself. Mr. Scott's voice breaks into the narrative. He begins to plead. He does not argue the law. He does not dispute the facts. Instead, he offers a desperate request. Release him again. One more chance. A chance to comply. A chance to regain control of his life. He speaks quickly, almost breathlessly, detailing the birthdays he will miss, the health treatments he requires, the job he hopes to start. He promises that this time will be different, that he has learned from his mistakes, that he will follow any condition the court imposes, tether, house arrest, supervision, whatever is necessary. This plea is sincere, but sincerity cannot erase a pattern. The judge listens quietly. There is no anger, no visible frustration, but a firm calm hangs in the air. The judge is reminded of the previous appearances. He recalls the times when Mr. Scott promised to comply. He recalls the conditions that were previously imposed. He recalls how those conditions were ignored, how trust was extended and broken, and how patterns of violation continue despite opportunities for correction. In this courtroom, words are weighed against history. Actions carry more weight than promises. And patterns, once established, are extremely difficult to ignore. The court's role is not to punish for the sake of punishment, but to prevent predictable outcomes. In this case, the outcomes had already proven themselves, and the risk of repetition could not be overlooked. The deputies in the courtroom remain alert. They understand the history, the volatility, and the stakes. This is not a routine appearance. Each movement, each word, each pause is part of a larger narrative. The courtroom itself feels like it is holding its breath, waiting to see if history will repeat itself once more. The defense reiterates Mr. Scott's hardships. They remind the court of the practical consequences of continued incarceration. Social, security, medical treatment, employment, family connection. All valid considerations, all weighed carefully against the backdrop of repeated violations. The court must balance human compassion with systemic responsibility. The scales are delicate, and every factor is scrutinized with precision. The prosecution emphasizes the role of law enforcement and public safety. They explain that the conditions were imposed not to inconvenience Mr. Scott, but to prevent risk to officers, the public, and the structure of the legal system itself. When the defendant disregarded the conditions, the predictable result was conflict, escalation, and new charges. The court now faces a decision that is not about theory or hypotheticals. It is about reality and probability. The judge leans slightly forward. There is no rush. There is no need for dramatics. Decisions like this are not made on impulse. They are made on reflection, careful calculation, and consideration of all factors, human, legal, and procedural. The judge reviews the file silently, recalling each previous hearing, each promise made, each condition broken. The record is complete. The pattern is clear. History is speaking. Mr. Scott continues to plead. He promises change. He appeals to compassion. He emphasizes his need for release to continue with his life, to care for his health, to maintain his employment, to reconnect with his family. He offers any restrictions the court requires. He offers obedience. He offers cooperation. But at the heart of the matter, the court asks a single question. Can this pattern of repeated violations be trusted to end now? The courtroom remains tense but composed. Each participant understands the gravity. This is not about drama. It is about risk management, about foresight, and about protecting a system designed to prevent chaos. The law is not measured by emotion alone. It is measured by outcomes, precedent, and the likelihood of repetition. The judge finally speaks. His words are calm, firm, and precise. He acknowledges Mr. Scott's sincerity, his hardships, and his intentions. But he cannot ignore the repeated violations. He cannot gamble the present on promises that have been broken before. He must act based on history, patterns, and probability, not on hope alone. The first part of the hearing closes with the court's message clear. Second chances exist, but they must be grounded in demonstrated behavior. Trust, once broken repeatedly, cannot be extended lightly. The courtroom prepares for the next phase, knowing that the decision will set the tone for the defendant's future and for the enforcement of the law. When Mr. Scott begins to speak, the atmosphere in the courtroom shifts subtly but unmistakably. Every word he utters is weighted with urgency, fear, and desperation. He does not dispute the allegations. He does not deny that he violated the terms of his bond. Instead, he pleads for one final opportunity, one last chance to regain the freedom he has repeatedly lost. His voice, though shaky at moments, conveys sincerity. It conveys an almost palpable fear of the consequences if the court refuses. Him once more. He recounts the birthdays he will miss, his grandmother, his brother, his sister, moments of family significance that would pass without him if he remains behind bars. He speaks of health concerns, describing the medical injection that cannot be administered within the jail system, a $10,000 treatment covered only by insurance that operates outside of custody. He emphasizes the immediacy of this treatment and the serious consequences of any delay. He stresses his new employment opportunity, the chance to start fresh, and the impact continued incarceration would have on his future stability. Each point he makes is designed to humanize the argument, to remind the court that he is more than a name on a docket, more than a record of violations. He is someone with responsibilities, obligations, and potential for change. Mr. Scott goes further, offering any conditions the court deems necessary: house arrest, tether monitoring, strict supervision, any form of restriction that would allow him to demonstrate compliance and responsibility. He does not resist control, he embraces it. His willingness to submit to strict conditions is meant to reinforce the sincerity of his plea. Yet, the court listens not only to the words, but also to the history that accompanies them. History, after all, has the final say in such hearings. The judge remains calm, measured, and deliberate. There is no visible frustration, no raising the voice, no theatrics. Instead, there is a sense of deep, considered reflection. The judge recalls previous appearances, the previous promises made and broken, the previous violations that have shaped the court's expectations. The courtroom itself feels the weight of repetition. Every deputy, every attorney, every observer senses the pattern that has developed over time, the cycle of release, violation, and return. Mr. Scott insists that he has changed. He claims that his time in jail has taught him the lessons he previously ignored. He promises that if released today, he will abide by all conditions. He acknowledges the risk he has posed in the past and offers to accept any consequence if he fails again. This acknowledgement, while sincere, collides with the hard reality of repeated behavior. The court must balance human empathy with systemic responsibility, and the pattern of repeated violations cannot be dismissed lightly. The prosecution emphasizes the role of law, enforcement, and public safety. They note that every time Mr. Scott has returned to prohibited areas, police have been required to respond. Each incident creates risk not only for Mr. Scott, but also for the officers and the community. The prosecution highlights that the court's conditions are not arbitrary, but are carefully designed to manage risk and prevent escalation. The court is reminded that ignoring patterns of repeated violations could lead to serious consequences, situations the legal system is designed to prevent. The judge addresses Mr. Scott directly, acknowledging the emotional weight of his argument and the practical difficulties he faces in custody. Yet the judge's reasoning is methodical, rooted in logic, precedent, and risk assessment. The judge explains that bond hearings are not about punishment, but about prediction. They ask a single fundamental question: if the defendant is released today, what is the likelihood that he will comply with the conditions and not create additional harm? This question cannot be answered by promises alone. It must be answered by patterns of behavior. Mr. Scott responds with emotion, repeating his plea. He emphasizes the urgency of his medical needs, the significance of his upcoming employment, and his desire to reconnect with family. He assures the court that he is willing to do anything necessary to prove his compliance. Yet, with every repetition of his plea, the judge recalls the repeated history of broken promises. The courtroom has witnessed cycles of trust extended and violated. This history cannot be ignored. The deputies prepare for the procedural aspects of the hearing, standing ready to escort Mr. Scott if the court denies release. The tension in the room is palpable, but controlled. Everyone present understands the stakes. This is not a simple decision. It is a judgment that weighs freedom against risk, intention against behavior, hope against history. The courtroom is silent, save for the careful exchange of words between judge, defense, and prosecution. Finally, the judge delivers the decision. His voice is calm, authoritative, and deliberate. Mr. Scott's plea is acknowledged, his hardships recognized, and his intentions respected. Yet the judge is unwavering in his conclusion. Release is denied. The court cannot gamble on the possibility that history will suddenly reverse itself. Risk, pattern, and precedent take precedence over emotion and intention. The decision is not a punishment, but a necessary precaution. Mr. Scott asks for clarity on when he might be released in the future. The judge responds honestly, eventually, but not today. The door is not permanently closed. The opportunity for a second chance exists, but it must be earned through demonstrated compliance and change. The court's message is firm. Second chances are conditional, and repeated violation diminishes trust. As the deputies prepare to escort Mr. Scott back into custody, the courtroom maintains a composed silence. There is no spectacle, no emotional outburst. The record is updated. Future court dates are set. The procedures continue. The courtroom moves on, yet the lesson remains. Trust, once repeatedly broken, cannot be extended lightly. Second chances are meaningful only when paired with consistent, reliable behavior. This hearing is a study in human behavior, risk management, and the delicate balance between empathy and responsibility. It demonstrates the judicial system's role in containing potential harm while respecting individual circumstances. It shows how repeated violations test not only the defendant but the system itself, requiring careful evaluation of when trust may be extended and when it must be withheld. The courtroom empties slowly, the echoes of the hearing lingering in the minds of those present. Mr. Scott remains in custody, not because guilt has been established, but because uncertainty carries too high a cost. The law prioritizes prevention over optimism, control over hope, and safety over convenience. In this case, the system has spoken. Patterns cannot be ignored, and trust must be earned through consistent action. The final message is clear. While second chances exist in principle, they are not limitless. When the same chance is repeatedly given and repeatedly violated, the court stops listening to words and begins to observe patterns. In this case, the patterns were decisive enough to determine the outcome before a single word could change it.